As noted off the record, these motions were facilitated by the Kent County Front of the Court. So I will let the Front of the Court place on the record the facts of this matter, and then we'll review it, and I will hear from both parties. Mr. Jacobson, if you care to proceed, sir.
Yes, Your Honor. The parties are parents of three children. Two of them are minors, one 15 years old and one 11-year-old. The order that we're referencing today are dated 6/19 of 2018, and the judgment of divorce June 11th of 2015. The mother filed complaints to the front of the court, reporting on Thursdays. Let's see. Got
Yes.
September 7th, 14th, the 21st, October 5th, October 19th, October 23rd, November 2nd, November 16th, November 30th. Almost all of these are Thursdays. They're all Thursdays, but all of them but one are that the father failed to return the child back to the court-ordered exchange location at the East Grand Rapids Library. There's one where there's a complaint that he didn't show up at all for his parenting time. We did get a response from the father on two of the dates that on 9/7, he's alleging that the mother told him she wasn't gonna be there and that he gave a 48-hour notice that he would forfeit his time on 9/14. At this time, the front of the court will withhold a recommendation pending testimony of the parties.
All right. Sir, you're the one that has been requested to be held in contempt, so I will hear from you first.
Thank you.
Well, hold on. The 14th or the 19th, you said you gave her 48 hours notice. Mr. Jacobson, how many total violations do we have?
Violations.
I tried to keep up, but I don't write that
Yes.
fast.
1, 2, 3, 4, 5, 6, 7, 8, 9.
Okay. 9, but one of which allegedly he said that he gave her notice. Okay.
Yes.
Please proceed, Mr. Sturgis.
Thank you. First of all, it's in Colton's best interest to keep his schedule consistent. The plaintiff, in writing, proposed 12/20 of 2020 that on the off weeks to my regular scheduled parenting time, I have my sons, plural, stay overnight, and I take them to the school the following day. I agreed. This has been Colton's schedule for the previous 3 years. So I do not see how this change benefits Colton or any justification has ever been provided. Colton has had the task of going from private Catholic schools system to an inner city school, of which is set to close next year, resulting in even more change. Colton has behavioral issues, and he suffers from anxiety, of which I am currently working with Colton's teachers to help him resolve. My goal as his father is to keep Colton's schedule as consistent as possible, and the court rule in Colton's favor to be able to do so. It's important for me. I have one more thing, Your Honor.
Yeah.
What we're discussing is 45 minutes at night and 45 minutes in the morning. So the court order.
How is it 45 minutes?
Good question. The court order prior to us doing this for 3 years at the plaintiff's proposal has been for me to drop Colton off and Quinn at 8:15 on the off weekends that I do not have court-ordered parenting time.
8:15 p.m.?
Yes, sir. So basically then Colton goes to bed at 9 o'clock. So that's 45 minutes. In the following day, taking Colton to school, he wakes up we get him ready about 6:30, or rather he gets up about 6:30, 6:45. We set out his clothes for the following day. He has breakfast if he chooses to, or he can have breakfast at school. And so then there's another 45 minutes. So in all, what we're discussing is bedtime and a maximum of an hour and a half. So again, this has been Colton's schedule for the previous 3 years, proposed by the plaintiff. We've agreed, and we've been doing it.
Say that you have that in writing from her.
Yes.
And signed by her.
She didn't sign it. She sent a text message, and we've had that text message.
You still have that text message, and it shows it's from her number.
Correct. And we've been conducting
from 3 years ago.
Yeah, from 12/20 of 2020. And the reason why we've had this is because periodically she will say that she doesn't want to do this anymore or whatever. And So this has gone in front of Guy Jacobson in the court, friend of the court, and they have ruled in my favor that that because they just said that there was a complaint filed and then they reviewed it and then they dismissed it. So now this is the new time that we're now here again.
All right. Miss Linnell, did you send such a text?
I sent something 3 years ago,
Right.
but understanding that it was going to be a trial thing. And the problem is there's a lot of other things that came into play with that. And he wasn't even willing to work with me. This has been
Okay. Well, hold on. You sent the text 3 years ago. Has this young man been staying predominantly with him on these Thursday nights since you sent that text?
Yes, but only because for 3 years we've been going back and forth. And right away I saw it wasn't working. And
But it's been 3 years.
right. And I'm the one that filed something a while ago and it was going to come to court and I dropped it. But I have
Okay, it needs to get to court because
right.
bottom
And
line, the court is going to follow what the child is used to. And if he's been used to it for 3 years, the court's more than likely going to back that up.
okay.
I mean, you're the one that sent the message. If it's been going on and now you want to complain about these 8 or 9 times recently over the 8 or 9 weeks, but it's been going on for 3 weeks, that's not a complaint.
I would like to.
Yeah.
I don't feel like you're letting me speak, and there's a lot of
Well, I was
reasons.
trying to explain, what position you're placing the court in, but please explain.
You don't know what it's been like to be a single
You're right,
parent.
I don't.
I
don't.
It is almost impossible to have anything unless it's in writing. Even Mr. Jacobson understands that. I dropped it for the sake of my other son because of what he put his other son that no longer goes. The other two children have nothing to do with him. There's a lot of underlying issues here, and I have tried to keep it out of the court for their sake. But Colton does not like it. It has been a stressful situation on my whole family because of this. And it has gotten to the point where he's lied and said he had COVID and he went to Florida and he stopped. And there's a lot of them that I haven't written up. And I've just begged him to just stop doing this every other Thursday because it has been very stressful for Colton. In fact, I don't even think he should.
Does he not do well in school on the Friday morning after he's dropped off?
It's too much.
Do you have those records? Do you have them showing that he's not doing well in school on the Fridays after he spends an overnight with his mother?
I could probably get something from the teacher.
I would suggest you do so, and I would suggest that you file a motion. And then, sir, you need to file a motion. Because bottom line, I can only enforce the order that's enforced here. The problem is I can only enforce it if you guys have been following it. And it doesn't sound like you've been following it. If you're not following the orders as written, there's always an underlying rule in every case that says any other times the parties agree. It sounds like you made an offer, ma'am, and it's been followed for, if you'd been here 3 months after it started and you said this isn't working, I'd have looked at you and said this order is going to be enforced and we're done.
So
but it's been 3 years.
Right. And I've endured this whole time with my son, and I've let this go on because it's stressful dealing with this stuff, and you're just trying to do what's best for your son. And it's just been a nightmare. And the problem is, it doesn't look that way to you, obviously, and to
no. What it's not. I don't have any of that information. It's not that it looks to me or not looks to me.
Okay, I've had to change schools. I've been the one for the schools. I've been doing everything for my son. I had to find the school at the last minute, which he wasn't even about. And it's picking up all the pieces and then him playing the armchair quarterback every other weekend and thinking he's doing it. And then it takes him 5 months to just pay child support. I mean, there's so many hurdles that have gone through that it's exhausting trying to deal with the Thursdays and trying to send messages saying that this hasn't worked. I said this a couple of years ago that it didn't work. And the problem is that nobody takes in consideration the snow days, the times that he'll keep them over the next day because of the snow day, the summer schedule. It's not that easy. And then he expects me to make it go to the library. There's all these little things that you don't think about that come into play that causes problems for my son. And it actually adds to everybody's anxiety. For my anxiety,
And the court is
And
more than willing to listen to all of that, but you have to put that in a motion where the court can actually review it and
I'm
have the
trying to
knowledge.
get out
I,
of it because I just wanted to deal with this, because if we could keep things just lined out of court, it's better for me, it's better for my son.
and
If
I agree wholeheartedly with you. And like I said, if you'd have brought this 2 or 3 months after you sent that letter, fine. But if this has been going on for 3 years, I can't hold anybody in contempt because you're not following the court orders.
following the
You've
court,
you've
not
you've
in court,
the court order only gives him a Thursday night, a Thursday evening. But
okay,
by allowing this to happen for a long period of time,
okay,
how am
but
I supposed to hold him in
again,
contempt
I,
for something that you've allowed to happen for 3 years?
but it isn't in the court order.
You're
This is
right,
an
it's not in the court order.
that I
But this is something the two of you set up.
no,
So
I
how am I supposed to enforce an order that neither one of you are following?
always me that has to give him time or try to work with his schedule.
That's because you have the majority of time.
He's not
So
flexible to even drop my son off when I need, when this happens. It's a mess. He is not easy to work with, and I have to do
well,
everything. So
then again, I suggest that you file a motion, but I can't hold anybody in contempt under these facts because you're not following the court orders.
what about when he doesn't come for the weekend and just decides he's not going to be there because he's sick or something happens? I mean, that message.
Well, if he's sick, do you really want the kids going over there? And is he giving you enough notice to say, look, I can't make it?
From somebody else that he went to Florida. He's not even supposed to leave. I mean,
How's he not supposed to leave?
he went to Florida for the
You
weekend.
you don't get to control his life, neither does he get to control your life.
No, but he is not supposed to leave Michigan.
Why? What order says that?
There's something in his.
So you're saying that your ex-husband can't leave the state of Michigan
No, he's not
without your
supposed.
permission?
Not me.
It's called the
Probation.
Constitution of,
He's on
you know,
probation.
well, in that case, there's a court order and a court case that would have to follow that. It's not under this court's purview. If he's not now that's a whole different matter. If he can't leave the state of Michigan because he's on a probation through a criminal matter, then that needs to be reported to his probation officer, and the person who knows of it should report it. But the probation officer is probably not going to listen to a hearsay argument saying, I heard a friend tell me that he's out. So that's a whole different matter. But under the family law case, I can't stop somebody from traveling.
My point is, he doesn't show up for his weekend every other weekend. He's done this more than
How
once,
often? How often has he not shown up for his weekend?
about 3 times
During what period of time?
in the last couple of years.
Okay, sir, why didn't you show up for those weekends?
Tired of him doing that stuff last minute.
Sir, why didn't you show up for those weekends?
In the previous, let's just go back 3 years. I think maybe one of the times my car broke down, and the other 2 previous times I was sick. But in 3 years,
Okay. And ma'am, you mentioned the fact that he was sick. Did you know about the breakdown of the car?
Yes,
And
I knew.
and was that told to you prior? Was that told to you prior to the weekend happening?
No, he just told me last minute, like the same day. I mean, it's that
Well,
kind
I
of.
mean, a car breaking down generally is last minute. And so sometimes is getting sick. You don't get 72 hours warning on, gee, I threw up this morning. I'm sorry, folks. I can't hold him in contempt. You both need to file a motion to figure out what to do about the parenting time because it's not being by the current court order. The court cannot enforce something that you guys haven't followed. So have a good afternoon. I wish I could help you, but you're bringing up all kinds of stuff that is not in any of these filings and the court has no knowledge of. I have a crystal ball in my office. It still does not work. Trust me, I try every once in a while, but I don't know everything. And you guys throwing this stuff in my lap right now, but you're telling me the ultimate is you offered this, ma'am, 3 years ago, and it's been going on for 3 years.
Not by choice.
Somebody,
you're
the one that started the choice. So my suggestion is somebody file a motion, or both of you file a motion, so that I can get this to the front of the court, and all that information can be written in those motions because the front of the court will then look at that information and be able to sit down with you and vet this out. But right now, I can't enforce an order that the two of you have